All right. Well, thank you everybody for joining us today. Just a reminder as we get started that we're going to be recording this webinar and we'll be sending that out along with some resources in the coming days. If you have any questions during the presentation, please feel free to drop them in the Q&A box and we'll address them towards the end of the webinar. We know that this new workplace safety legislation and the requirements that come with it is a hot topic right now, and we've been focused on building awareness and curating educational resources you need to feel more comfortable moving forward with a workplace violence prevention plan. That's why we're honored to have Andrew Sommer, partner at Fisher Phillips Law Firm, with us today. With more than 2 decades of employment litigation experience, Andrew defends employers in workplace safety inspections, investigations, and enforcement actions brought by Cal OSHA and other OSHA state programs, advises companies on workplace safety compliance, policies and procedures, and conducts compliance audits and training. So with that, I'm going to hand it over to Andrew.
All right. Well, thank you, Nick, for the introduction. I really appreciate Morris and Garetano inviting me to speak. This is a topic near and dear to my heart. So I'll have lots of information for you. I will first of all apologize on behalf of the state of California for this law that was created. As I think it came from a very positive place. I think the legislature really wanted to make the workplace safer from a violence standpoint. And there was so much in the news that they wanted to address. But as my grandmother used to say, the road to hell is paved with good intentions. And so this law is particularly onerous. So I wanted to walk through the requirements. Also, I will explain some of the resources that our firm has and that could help you along in this process. So, I'll first start out in terms of the agenda with the application. Does this apply to you as a business? What are the general requirements? The compliance resources that are available, and some frequently asked questions that were posed by Cal OSHA recently with some answers. I think they're lacking generally, and there's other issues that have certainly come up in the advice that we provide our clients that may be in the questions that you type in today. So certainly during the presentation, feel free to type in any questions that you have and we'll address them at the end. We'll definitely leave time for questions. So there's a big backstory to this law. I won't bore you with those details because there's so much to talk about, but basically this was supposed to be a Cal OSHA rule developed by the Cal OSHA Standards Board, which has been the historic practice. But the legislature stepped in, motivated largely, by the influence by organized labor and the perception that the Cal OSHA Standards Board wasn't moving fast enough on this. And so they decided to legislate this. And as is often the case with legislation, they're not on the ground understanding the issues like you all are as employers. And so there's, many things in here that just are challenging to implement that may derive from a lack of real understanding and appreciation for how workplace violence can be addressed effectively in the workplace. But just want to give you a broad framework. So I'm a employment litigator. I do wage and hour litigation among other areas, and I'm also a Cal OSHA attorney. So a lot of my perspective here will be as an OSHA attorney and how I expect Cal OSHA to enforce this law and my recommendations for you all. Now, the law, there's been some confusion about this since this is a piece of legislation, state law, about whether Cal OSHA can enforce this. But Cal OSHA definitely under the law has authority to enforce this. So they will be out in force in inspections that they conduct, asking to see the workplace violence prevention plan, confirmation of training. And if workplace violence is an issue in the inspection, I expect them to go deeper and want to see that you properly implemented, or at least in their view, effectively implemented the plan. So the core component here, it's like those of you who are familiar with the Injury and Illness Prevention Program, it has similar verbiage. It's essentially there's a requirement to establish, implement, and maintain the plan, and the plan needs to be effective. And so the compliance date is July 1st, and it's really important to note that that is the compliance date for everything related to this law. So it's having your plan, implementing it, conducting your risk assessments, and conducting your training. So it's a whole lot to do. My public service announcement for the day is start now. Don't wait any longer, because I think, 2 months you can get this done. But if you really wait till June, I think it's going to be a challenge. Also, if you need support from our firm or others, it's going to get particularly vexing the last month as we go into the July 1st deadline. So, just going back just to the core requirements here, this workplace violence prevention plan needs to be in writing. It needs to be accessible to employees and their unions, if you have any, and it needs to be in effect at all times and at all workplaces. So it needs to essentially be implemented throughout your organization. And it has to be specific to the hazards and corrective measures for each work area and operation. So the big takeaway here is you can't go online and just buy something that's generic and just say, okay, here's our plan, we're going to use it now. You typically could do that to some degree with the injury and illness prevention program, but because of the requirement that it be tailored to your workplace, to the hazards in your workplace, it has to be customized, at least at some degree. In our, I'll get to this at the end, the templates that we provide do have a lot of generic kind of best practices, but then they do need to be tailored a little bit. This plan can be a standalone plan, or it can be part of the injury and illness prevention program. For a variety of reasons, I tend to find it preferable to have this as a standalone document. But this is a question we get all the time. I understand there were a number of you that before the presentation today posed this question: does this apply to me? And so I think we all want this not to apply because there's so many requirements here, but it's quite broadly worded. In the past, we've had a workplace violence standard for healthcare, and that's been, that was targeted on that industry and the perception that there's a greater risk of workplace violence in healthcare. Now, we were hoping that this general industry standard would be targeted to certain industries, or at least for certain requirements, but no, it's very broad. All of these onerous requirements apply to all employers, all places of employment, and also employer-provided housing. But there are some exceptions that I'll go over with you. So, healthcare facilities that are already covered by the Cal/OSHA healthcare workplace violence standard are exempt, understandably, because they're already covered under a similar law. Now, and there's also an exception or exemption for places of employment where there are fewer than 10 employees working at any given time, and where the workplace is not accessible to the public. So if you have a very small workplace, you don't expect to have more than 9 employees at any time, then you may be exempt. But the caveat here, and I consider this to be somewhat illusory, because there's not many employers that can take advantage of this exemption, because accessible to the public is not defined. But just given my experience with Cal/OSHA, I would see them construing this rather broadly. So if you have customers that come on site, vendors, messengers, technically that's access to the public. So, I mean, it could be that we get FAQs from Cal/OSHA in the future where they take a more narrow view, but we don't have that. And given that, I would be quite careful in determining that you fall under this exemption. And this exemption only applies to specific locations. So you could have one location that has 10 or more employees that is subject to the law, and one with fewer than 10 that's not. The other exception is for employees who are teleworking from a location of the employee's choice, which is not under the employer's control. So if an employee says, they have the option of working remotely, and they, pick their home as the place, or maybe some other location, then that individual would not fall under the law, and so the plan would not need to be applied. They would not need to undergo workplace violence training. Now, another caveat here is, what if you have an employee that's teleworking, and then they decide to come in the office one day? They come in the office for a meeting once a year. They would fall under the law to the extent that they come into the office and meet with others. So you got to be careful with that. I mean, if you have an employee that's out in Dakota, you know that person's never going to come on site, and they have no reason to interact with others outside of their home and performing their job. They don't have customer meetings, things like that. You could just consider them to be teleworking, not subject to the law, and not train them. But if you think there is a potential for them to come into contact with employees in the workplace or outside the workplace with customers or others, then I would consider training them along with the rest of your workforce. We can get into the training components. We'll do that in a moment. So what is workplace violence? Some of it's intuitive and some of it is not. It's two parts. It's an act of violence or it's a threat of violence. It has to occur in the workplace. The workplace could be your actual office, warehouse, other facility that you operate. It could also be outside of the office. Say you have meetings among employees. If it has some sort of connection to the work that you do, it could be considered the workplace. But let's just go over the components here. So it's a threat of physical force or the use of physical force against an employee. And so it's that results in or has a high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether employee sustains an injury. So the takeaway is the employee doesn't need to be injured. So we kind of know it has to have a likelihood. So if it's something, and sometimes it may be a credibility assessment by the employer in an investigation to determine whether this is a bona fide act of violence or threat of violence. For an act of violence, it's usually pretty clear, right? Threat of violence, not so much. You could have a situation where an employee says, the supervisor was bullying me. This is workplace violence. And you look into it and you're like, this is not workplace violence. It's not a threat of the use of physical force. We're not going to treat this like a workplace violence incident. We might address this under our EEO policy, but not under the workplace violence policy. And then it can also involve the incident involving the threat or use of a firearm or other dangerous weapon. There is an exception. Workplace violence is not lawful acts of self-defense or defense of others. That's somewhat perplexing because the underlying event would likely be workplace violence, but your self-defense and response would not be considered workplace violence. So there's 4 types of workplace violence under the law. And I won't dwell on this because I'd like to get into more of the substance, but a lot of it will make sense to you. It could be workplace violence committed by a person who has no legitimate business at the work site, someone that just comes on site. It could be an active shooter situation. It could be a theft situation, trespassing, whatever it may be. Type 2 violence is usually or is considered violence by a customer or client. It could also be a patient if you have patients, other individuals that have permission to come on site, but then commit some sort of act of violence when they're there. Type 3 violence would be violence committed. Again, these are all violence committed against an employee. And here it would be against an employee by a present or former employee. And type 4 violence. And, I'll say we can share our slides. I will provide them to Morris and Garitano, and they can provide them to you either upon request or just email them out. So there's a lot of content here that I just don't think we have time to go into today, but you can certainly peruse it afterwards. But type 4 violence is violence committed, essentially a domestic violence type situation typically, but it's committed in the workplace by a person who does not work there, but has a personal relationship with an employee. So it could be a spouse, someone that the employee's having a romantic relationship. It could be a falling out. It could be another scenario, or it could just be a friendship with someone because of their relationship who has otherwise no connection to the workplace, comes on site, and maybe in the situation where they're targeting that employee. Okay, so just getting into the nuts and bolts here. It's not adequate just to create a plan. So there is an obligation to establish the plan, and the plan has various elements, and it's fairly comprehensive. And I think that's the easy part. The much more difficult part is implementing it. So you're required to implement and maintain the plan. So that requires that you actually communicate the requirements under the plan to your employees, to your supervisors, and you develop certain measures in place so that if there is a workplace violence incident, you have procedures in place to respond. So some of the requirements are, having reporting procedures so employees know that, with no threat of retaliation, they can report a workplace violence incident. And that you have a procedure for investigating reports of workplace violence. And then once you investigate it, that you take appropriate corrective measures if necessary. And that you also, and this is a really important one, that you have a procedure for identifying workplace violence hazards and assessing them and then correcting them where necessary. The word implement, it's just basically all these things that you need to do in furtherance of the plan, completing inspections, communicating with employees on hazards, conducting employee training, of course, too. Okay, so I'm just going to walk through now the nuts and bolts of what's required for the plan. And then I'll get into some of the nuances that we're all kind of perplexed over, given how the law was written. So you must have a workplace violence administrator, and you have to identify that person. So your employees know, who's responsible and who they can reach out to. You have to identify at least one person, and the workplace violence prevention plan administrator should really be someone that's in a management position, has executive management skills, can manage a project of this size. And you really only need to have one for the whole state. So if you have many locations, they can oversee an overarching program throughout the state. And then I think it's advisable to have individuals under that person that have different responsibilities. Like oftentimes it's human resources that would monitor that training is being completed, that you're adequately responding to employee reports of workplace violence, that you're conducting your investigations. In my years of experience, it's really the HR that has the best kind of capacity, ability to address these types of situations. It could also be someone in a safety role or even loss prevention. It really just depends on your company and the expertise of your folks. And then I would also identify a contact person at each workplace, and that's more practically if there is a incident in the moment. The employee might not have time to contact HR, which could be somewhere else, and that there'd be someone on site they can immediately go to. And so, each individual's role, must be clearly described in the plan. But there's different ways you can go about the tiers of responsible individuals. Another key component, and this is just reflective of the nature of affairs in California, is there's a desire to include unions, to include employees. And the law, it's written into it that you must describe how employees and their unions, if you have them, will be involved in developing and implementing the plan. Employee participation includes their participation in identifying, evaluating, correcting workplace hazards, designing and implementing training, and reporting, investigating incidents of workplace violence. So it requires that you provide employees the opportunity to participate and encourage that. So there's ways you can go about this. Just reading this plain language in the law, it suggests that every time you are at this phase, for example, of conducting your hazard assessment, you have to reach out to your employees and say, do you want to participate? And those who want to participate, reach back out. The problem with that is that's a lot of hoops to jump through. And for you to have to do that repeatedly, invariably you're going to miss a step here and then technically be in violation of the law. So one approach that we've thought up is you could create a control, like a workplace violence review group it'd be almost like a safety committee where you could invite a couple employees to participate. So you could have management, some employees, the workplace violence administrator, and then as you work through the issues, because you really need to like be working as a team through this, in my view, then you could ensure that you would have employee participation. And you could send an email out just inviting employees to participate, and you could pick who you want. Obviously, if you have an employee that's on the ropes and they're about to be terminated, you probably don't want that person on your review group. They might have another agenda, or it might just be an employee that's not terribly constructive and thoughtful, whereas you have others that are. So that's one approach. There's other ways of doing this. They don't make clear exactly how you have to encourage employee participation. And then another really challenging requirement is coordination with other employers. And the employer is required to specify in the plan how they'll coordinate the implementation of the plan with other employers. So if you have other workers on site that are employed by others, you'd want to communicate not with the workers, but with their employer. And you just have to be careful how you do this, because you don't want to create a joint employer relationship or multi-employer, or else then you're seen as the employer of your of these workers that are employed by others. So you want to share your plan with those other employers, remind them that they need to train their workers on the plan and workplace violence. And so it really varies. I mean, if you have a consistent presence on site, then you know who it is. If you have like a messenger that comes on site every now and then, you're not going to be able to coordinate with the employer of the messenger. And I would doubt that that's what the legislature intended, but how it's written, it's a bit problematic in its scope. And then if you are an employer that has workers that go to other sites, then it's the shoes on the other foot, and what you need to do is train your workers about how to deal with the situation where they go to other employer sites. If they're at one location or a couple all the time, you can be more comprehensive and specific to those locations. If they're going to many sites, you probably can't be that detailed, just practically. Okay, and then another component here is just to have a procedure for accepting and responding to reports of workplace violence. I do want to emphasize that the requirement is that these be effective procedures. So you have to show that they actually work. And so that does require a whole other kind of layer of kind of thought and effort. So you want to identify how an employee can report a workplace violence incident, like who to go to, specifically contact information for those individuals, and then make it clear, how you will respond generally. And then that there won't be any retaliation for making such a report, of course. So that needs to be included in the plan. Okay, and then you're required to ensure employee compliance, and that can be done by a variety of things. Of course, training, taking disciplinary actions for employees that do not comply. That you need to be careful that you do that in a way that doesn't come across as retaliatory. You can also reward employees for being proactive as to these matters. And then you want to communicate with employees. Of course, one very important way of communicating is through the training, but there may be other ways, and that can be through email communications, toolbox talks, or meetings just in the workplace. It can be following up after there is an incident or a concern that's raised. And then emergency response. This is an important one in particular, that you identify, how employees can report workplace violence concerns to their supervisors in the workplace, as well as if there's not time to reach out within the company, or if they prefer just to reach out to emergency services, how they can go about doing that. You'll want to have evacuation or sheltering plans. For example, an active shooter situation, you may already have emergency action plan that has some of these steps, and this is something you'd want to incorporate to a degree in your workplace violence plan. Okay, so training. Training is one that has created a whole bunch of concern and discussion. And so here, what is difficult is, with harassment training, as an example, you can oftentimes obtain a harassment training module from a third party. It's fairly generic in nature, and that can be the bulk of your training. Here, the training must be effective, but it also must be tailored to the workplace. And I'll get through the actual verbiage that's in the law, but it can't be generic in nature. So really, it has to be based on your plan, which of course is tailored. So you really need to, you can always hire someone to do the training, or you can have someone in-house do the training, but it really has to be, ABC company training. It's just not a generic training. So it has to be effective training. And, under the outdoor heat illness standard, Cal OSHA Appeals Board has considered effective training to be training that, covers the elements that are required under the regulation, but also it provide information in a way that can be retained by employees, which is really a tall order because not all employees have the same capacity to learn and retain information. So what that means is you need to ensure that your training materials cover all the required elements, and that it's done in a way that employees can grasp and follow and be consistent with the training. So, and the training needs to be appropriate in content and vocabulary level. I don't really see that as a concern because I don't think it matters what the educational level is of your workforce. I think these trainings generally should be fairly straightforward. I don't see a reason to elevate it in language usage. And they also have to be in the language of employees, meaning that if you have a workforce that is not sufficiently fluent in English and speaks another language, you'd want to conduct the training in that other language and consider translating your plan into that other language. The training must be conducted when the plan is first established. That means by July 1st, you need to complete the training, and annually thereafter. Now, that is frustrating because there's many Cal OSHA training requirements that are not annual, and you have enough other things to be dealing with, but you do need to do this training annually. And the other concern is there's no grace period for new employees. So if you have an employee starting, say in August, after you've already done your company-wide training based on the effective date of the law, you're going to have to train them too. And so you're going to have to train them right away. So my recommendation is to do that on new hire training during onboarding. So when you do the onboarding, include workplace violence training there. And there are some circumstances where you may need to do refresher training if there's a new or previously unrecognized workplace violence hazard that has been identified, or you change your plan. But ideally, you don't want to change your plan before the 1 year mark, when you need to complete the review and before you conduct your next round of training. And I'll get through review some tips for training to make this less burdensome. But in a nutshell, you want the training to cover your plan, how it's accessed, how to participate in development, cover the definitions and requirements under the law, such as I've already covered. And there's various different requirements, but I think the one key consideration here is that you must cover workplace violence hazards specific to your employees' jobs and the corrective measures you have implemented, and how to seek assistance to prevent, respond to violence, and strategies to avoid physical harm. That's specific to your workplace. So that's where it's clear that just having a generic workplace violence plan and train on it is just not going to work, and it's not going to be considered compliant. You're also required to review the violent incident law and how it works. Not sure why that's included. I don't think that's really that key, but that's part of the elements here. I mean, that's more important for supervisors than employees to understand. Now here is one consideration that impacts the format of the training. You're required to provide an opportunity for interactive questions and answers with a person knowledgeable about the employer's plan. So I think important takeaway is that the person that does the training needs to understand the plan. I think that's a no-brainer, right? If they don't understand the plan, how are they going to train on it? But in terms of the interactive component, if you do a live training, that person should be able to answer any questions that are posed, and you want to leave time for questions. But after everything I mean, you're all probably horrified at this point about the training requirements. So I have some good news. So thinking this through, we haven't received any guidance from CalOSHA otherwise, but I think as of the present, it would likely be acceptable for you to do a remote like video training that's recorded. And you would just record it. I mean, you could do a live training initially, record that training, and then just replay it for employees as they're onboarded throughout the year. So you don't have to have one person doing numerous trainings, which would be fairly burdensome. But if you're going to do it that way, it's really important is that at the end of the training, you have, our templates provide that, but that you have a slide that states something to the effect of, if you have any questions, contact so-and-so. She can be reached at this phone number, this email. And as long as that person timely responds, I would think that would be compliant. I have no reason to believe it would not be. But if the person takes a week to get back, then I don't think that would be really interactive. I would say ideally they should get back to that individual the same day. So that's the training requirement. And then another requirement is a hazard identification evaluation. So what you want to do is before you even kind of stamp your plan as complete, I would conduct a hazard identification in the workplace and look at potential workplace violence risk factors. An example I can give would be if you have employees that work at night alone, or even just work alone in remote locations, one thing you might want to look at is, what's the safety to the building? Do you have secure doors? What's the parking lot like? Is there good lighting if they're working at night or early morning? And so, this is essentially a performance standard, the Workplace Violence Prevention Plan law. What that means, that's a term that's used with CalOSHA, and it's common with the Injury and Illness Prevention Program. What it means is you have requirements to do certain things, but it doesn't tell you exactly how to do it. You have different options, which makes sense because in the situation I just described, where you have employees working late at night, you might have different outcomes. Lighting might be the issue, but maybe the parking lot is not yours. You can't change the lighting. Maybe you can assign parking spots at the front door for folks that work at night. There's all sorts of things you can do. And so you want to address the matter adequately or the concern, but you can do it in different ways. So you want to go through this risk assessment, look at various workplace violence considerations, whether they need to be addressed further. And then based on that, you may need to tweak your plan a little bit and also institute some corrective measures. The inspections should occur when the plan is first established, so it's part of developing the plan, and then after each incident of workplace violence. And that may be sort of a check the box exercise. It may be that there's really nothing new that you need to do, just depends on the nature of the incident. And then you're required to also conduct inspection when the employer is made aware of any new or previously unrecognized hazards. Now, the one requirement is a little bit challenging is you are required to schedule periodic inspections. And so, there's so many other steps you're going through. There's a question about how often to do this, and there's really no answer. But I would do it at least once throughout that year before the plan comes up for its annual review, which I'll discuss in a moment. And then any hazards that are identified, you'll want to timely correct them. They don't say what you need to do to correct them, but it's consistent with what I was saying earlier, that there's various different measures you can institute depending on the nature of the incident, of the workplace violence concern in your workplace. Okay, and then you also required, I mean, this is really the heart of it, I think. There's so much in here that I don't think needs to be there, but this is, this is an important one, post-incident response investigation. So, if you do have an incident, you want to obviously timely respond because you may be able to prevent a major incident. You think about active shooter. You want to make sure that employees understand how to respond in that kind of, how to deal with that kind of situation. And there might be some kind of, how quickly you contact emergency services, how quickly management is deployed within the company, et cetera. And then there's measures post-investigation. So this is a requirement that at the end of the year, every year that you conduct a review of the plan, and that would be something that your plan administrator should be part of. If you have a review group, it could be the whole review group. I think a group reviewing this is a good idea because you might identify gaps. And a key thing, and this goes for anything Cal/OSHA, is document. So if you're reviewing the plan, document that you've done the review. Training, document that you complete the training. A risk assessment, document that. Cal/OSHA's view is if you don't document, you've never done it. And it's really an uphill battle to show otherwise. So you have the annual training. You're also required to, annual review of the plan. And then you're also required to review it if there's a deficiency that's observed or becomes apparent. If you conduct a thorough review initially, hopefully you don't have that situation where you find a deficiency. And then after an incident of workplace violence, you're required to conduct a review of the plan. And that, again, might be at the check the box incident because you might find that the incident has nothing to do with the efficacy of the plan itself. And then there's a requirement to complete violence incident logs. And you're essentially checking boxes about the incident. So really the process that you want to go through is if there is a workplace violence incident, conduct an investigation, and then in that investigation you would talk about the witnesses and what happened in your own assessment. And then you are required to create this violence incident log at the end. And that's different, that's more pared down. So you need to exclude personal identifying information. And the reason being is that this is something that can be requested by employees or their union. And so you don't want that kind of information out there. And there's certain, I'll get to this towards the end, but there are certain categories of information that employees are entitled to or documents. And so you need to be aware of that as you're creating these documents. So if there's sensitive information, you're not putting that in the document. Okay, so record keeping, again, you'll have the slides. You can see these requirements. You have to maintain for a certain period of time your hazard identification, documentation, training records, and violent incident logs, and then also records of investigations. So this is the issue I was talking about just a moment ago. That you'll want to be really careful with how you draft the hazard identification, evaluation, correction records, as well as the violent incident logs, because those can be requested by employees and their representatives. And you have to provide those records within 15 days. So if you have sensitive information there and you draft things in a way that you really wouldn't want to be out in the world generally, then you just have to be careful, thoughtful in how you create this documentation. The training records are a little more straightforward. You're just going to have sign-in sheets, probably some record of completion. You may have the PowerPoints, but that's not something that I would really be concerned about providing as much as the other categories. And so, for that reason, I really recommend HR oversight or oversight of someone else in management with the appropriate background of the hazard identification, evaluation, correction records, and violent incident logs to ensure they're appropriately drafted. So we're almost done here, and then we'll have time for questions. I think I really just got to the core of the issues. I wanted to review some FAQs, frequently asked questions, that were just recently posted on CalOSH's website. I really found them to be underwhelming. I think there's so many better issues that they should have addressed. But one issue that I find a little workplace violence includes any act of violence or threat of violence that occurs in place of employment. This includes animal attacks. And then employers are required to document the type of incident, whether it was an animal attack. I think the issue I have is the types of violence really indicate that it's violence by others, individuals, not animals. But based on this, if there is an animal attack, that's something you will need to address as a violent incident, and potentially log it. Another question was, do employers have to implement a workplace violence reporting system for anonymous reporting? I think we all kind of knew the answer to this already is no. There's nothing in the law that says there has to be an anonymous reporting process. I think generally that's a good process to have for a variety of reasons, whether it relate to workplace violence or harassment or anything else. But that is not required here. It says, does each work location need a dedicated plan, or can an organization use a corporate plan for all sites? And the answer is employers are required to ensure that their written workplace violence prevention plan is specific to the hazard and corrective measures for each work area and operation. So I'm not sure it answers the question. It's you have to address each work area, but it can be in one plan as I see it. So you can have one plan, but then if you have different issues for each location, you would want to address that. So I think of a situation where, say, if I have a client I'm working with and they have offices, they have warehouses, they have a retail location, all of those locations are going to have different workplace violence risks. But you could have one master plan and address the different risks and maybe divide it by category. And certainly the training you'd want to have tailored. So oftentimes, it's advisable to have the training different for different types of workplaces that you have. But where the workplaces are similar, they're all offices, you might have 10 different offices, they're all generally the same kind of configuration. Then, you would, the one plan, same issues, and the one training should be enough. How can employers make the workplace violence plan accessible to employees? I think this is, it's again stating the obvious. You don't have to post in the workplace, but you can have it available in different forms. So many companies will have it on their intranet and employees can access it. It's just always there. If there is not an intranet that's available, then it is a good idea to have a binder. You just have to make sure employees understand that these binders are available and generally what they have. Okay, and then I think this is the last question, but it states, I'm unsure of what CalOSH's enforcement interpretation would be for the training requirement when the plan is first established. Does the training have to be completed before July 1, or is there a grace period? And they basically say there is no grace period. All training must be done by July 1st. I think that was pretty obvious, but that is something just to reinforce that you'll need to make sure all these steps are done and that you completed the training by July 1st. Okay, so, all right, so now you're all probably getting stressed out by this. So there's a lot you need to do by July 1st. And I feel like the bearer of bad news, but we do have, CalOSHA does have a template plan, but it doesn't include risk assessments and investigation reports and all these other things, or like a training module. So you could use theirs. I wouldn't recommend using it in its entirety because there are some things that are written in a way that's not necessarily required under the law. It's more recommendations as I see it. And there's a lot of blanks. You still need to tailor it. I think our plan that we have with our firm, we spent quite a bit of time and energy drafting it. And I think it's much more user-friendly in my view. I suppose I'm biased, but I do think it's fairly comprehensive and easy to use. And you can purchase that from us. There's two options, and we do have a significant discount for Morris and Garitano clients. And so if you can email me, or you can email this workplace violence prevention plan email account at the bottom, and we can give you the pricing. But there's two options. One is we can just give you the template materials, and they have comments in them where you can kind of fill in the blanks, or explaining how to fill in the blanks. Or one of our attorneys can help you tailor it to your business. And it's just an initial tailoring. It's a couple hours time. You'll likely need to do more work on your own. I think the real benefit too is it includes a training PowerPoint that's based on the plan. So as the plan changes, the training will need to change, but it has most of what you need in there. So it's a really good head start. There's also some other add-on services if you want them. We do workplace violence training, active shooter training, and security assessments. And we have a security professional and safety professionals and attorneys, depending on the area that can do this. But yeah, you can certainly reach out on that. So I think now we're going to open up for questions.
All right, Andrew, thank you. We did have some questions come through. I'm going to try and group them like for like as best as I can. Kind of starting back towards the beginning, thinking through the employee count, the remote status of workforce. What if a remote workforce, or a workforce is 100% remote and there isn't a physical office? Do they still have to have a plan?
Well, no, technically you would not be required to have a plan or to training. But you do need to consider whether there ever is any opportunity that you are meeting in person or with customers outside of the office. And if that's the case, that may trigger a requirement under the plan. So you'll have to think this through. So if it's too conclusory and you just say, okay, we're all working remotely, that's done, no plan, you may find out there's situations where you do gather. I think the idea, if you look at the intent of the law, the idea is there a scenario where you can have a workplace violence incident outside of your home? And if you're congregating in a restaurant for meetings, something could happen there. You're coming to the office at some point, something could happen there, and that would trigger compliance.
Okay, how about kind of falling under that same category? Does this apply if employees only work in the field at a client's home?
I'm sorry, so they work in the field
and they work at clients' homes.
At home, yeah. I mean, that would trigger compliance in that. Let's see. I mean, could you fall under you're fewer than 10 employees? It's not entirely clear given the numeric threshold, since it's only one other person. I mean, if you're going to the home and there's just a couple people in the home, but from a practical standpoint, I think Cal OSHA would try to find a way to construe that to fall under the law, because of course, you go into someone's home, there's a really acute workplace violence risk. You don't have control over the home. You don't have access to other people that could come to your rescue if there were an incident. So I think that's an acute scenario where you should address that specifically in your plan and in your training.
Okay, great. And you mentioned at the start the notable exemptions for healthcare facilities that are already covered by Cal OSHA's existing workplace violence. Does that include long-term care facilities?
Yeah, I can't recite all of the healthcare type businesses that fall under it. It's not intuitive, but I do work with long-term care facilities, and I know that's kind of an interesting one, because skilled nursing, as an example, falls under the healthcare standard, whereas assisted living, memory care, that would fall under the new general industry workplace violence laws. They'd be fairly similar requirements, but there are some different nuances under the healthcare law.
All right, thank you. We got a couple questions in regards to volunteers. Do they fall under the same plan requirement?
Well, yeah, I mean, the law is designed, OSHA exists to protect employees, not volunteers, right? So technically, they wouldn't be able to enforce. So if there was an incident involving a volunteer, CalOSHA's enforcement mechanisms would be more limited. But we have to think this through. I mean, if you have a volunteer, there are volunteer situations where under the law, they're considered employees and they're entitled to compensation. So you'd want to first look at, is this person really a volunteer, or could they be construed as an employee? I know with organizations that are, what's the word I'm thinking of, where they provide a greater good. It could be a nonprofit that has a social service mission. There are situations where you can volunteer and you not be entitled to compensation. But for a private employer, it's more limited. And there was a case I recall years ago of a bank where they were saying, oh, we're going to have people volunteer to staff our ATMs. And they were like, no, you can't do that. They're considered employees. So you have to look at specifically what the individuals are doing. But I think regardless, you might want to, that's a tough one. I mean, I really would have to know more details about whether you want to train the volunteers on workplace violence as more best practices. But in terms of kind of compliance, you'd be really focused on employees. That's the focus.
All right, we had a question of how is workplace violence different from harassment laws?
Okay, that's a good question. So, I mean, you'd want to investigate both areas, but the harassment laws, there is a harassment law on the books in California that requires investigation and, addressing of workplace violence in certain ways. And that, I think both harassment and workplace violence you'd want to investigate in a more manners that you'd want to have a kind of impartial investigation, kind of dig deep into the issues and determine whether any corrective measures need to be taken. But the real difference is how you respond. Here we have, harassment, you have a policy in your handbook and you have general, procedures for investigating and corrective measures. But I think the workplace violence goes even further in creating this whole regime around this through the workplace violence plan. So you'd have different measures in response. And, as I mentioned with workplace violence, you're required to have the violent incident log. You're required to review your workplace violence plan document. It definitely goes a little bit further. And you might have different folks responsible for handling harassment within your company as opposed to workplace violence. And you can certainly have them on different tracks.
All right, thank you. In regards to training, you mentioned that it could be pre-recorded as long as there is confirmation. Is there a time minimum for the training? Does it have to be 15, 30 minutes, any length?
Yeah, I did a presentation and I got that same question. I had everyone raise their hands. I said, how many people think this needs to be 2 hours? How many people an hour? How many people a half hour? And I found most people were saying around an hour. And that's kind of where I would fall. I mean, the short answer is there is no time requirement. So theoretically, this could be a 5-minute training, but I don't think a 5-minute training would be seen as effective. We saw how much we went through in issues. Just in my experience, I would think you would need to have at least an hour. And it depends, you could have a really tailored, targeted training in an hour that could be effective. But I know if I'm your CalOSHA attorney and I'm handling an appeal of citations by CalOSHA and you've done a half-hour training, it's going to be tough for me to argue that's effective.
Yeah. And then this question regarding Spanish speakers, does training videos or PowerPoints for on-site training need to be completed in Spanish if some employees have Spanish as their primary language?
Yes, it should be. Our templates are translated into Spanish. But yeah, I would, let's see here. If an employee is fully fluent in English, like sufficiently, you could do the training in English. But if there's some gaps in their comprehension, because English is not their native language, then you'll want to conduct the training in the other language. I think where this gets tough is where you have maybe 8 different languages spoken in your workplace. Like you're going to have bandwidth questions. But I know for many workforces in California, there'll be a considerable number of employees that speak Spanish, so it's much more manageable to do that training in Spanish. And if you have someone on staff that speaks Spanish and is qualified to do the training, you could just use that person.
This question kind of covers a few that came in of our site-specific plans required, particularly from contractors or painting companies where they're out in the field doing various projects. Are there different plans required for each site?
I think you could do one plan for all locations, but then I think you want to address the different nuances by location within the plan and certainly in the training. And as I mentioned previously, the training could be separated by location, type of location, if that's more effective. But I think this question came up frequently early on after the law was passed is, what do you do if you have 60 locations in the state? Are you going to do a risk assessment for every location? I mean, that's rather burdensome. And so there's different approaches here. One could be, you could just do a risk assessment for each type of location. So under the example I gave before, you have retail stores, your warehouses, your offices. You do one for each type of location. So you have 3 risk assessments you complete. And then you just apply that risk assessment to the individual location. So if you have 10 warehouses, you have 1 risk assessment for the generic warehouse that you apply to all the locations. That's a practical way of approaching this. Another way that would be a little more robust would be taking the one that you did for warehouses for like a generic location and then sharing it with your management of the other warehouses and saying, is there anything you would add here? And getting their feedback, because there could be different issues. If you're in a high crime area, that's definitely a consideration. It might involve different measures for security, particularly in accessing the building.
Okay, thank you. I believe that pretty much covers the majority of the items. Again, there were questions regarding templates and resources, which you went over in your slide, but we'll provide that information in our follow-up email as well.
And I think I mentioned this, but when you, if you reach out about our templates, just put in your email that you're a client of Morris and Garatama so we can make sure we offer you the discount. But yeah, but I'm also, I just want to, the caveat is, you can use the Cal/OSHA model. I think ours is user-friendly. So it's just a question of assessing. If you want to develop a team and work on all these materials on your own, you can certainly do that. But we do have the templates available for you.
All right. Well, thank you, Andrew, and thank you everybody for joining us today. We'll be sure to send out some additional resources and links, both to the Cal/OSHA resources as well as instruction on how to access the Fisher Phillips material. So thank you for your time and take care.
All right. Thank you, Nick. And Sarah.